10 new Supreme Court rules just dropped like a bomb on every gun owner in America. And after the Martinez versus Thompson ruling this morning, police departments are scrambling to rewrite the rulebook in real time. In 10 new rules every gun owner must know after shocking court ruling today, we're exposing the brand new protocols that could mean the difference between keeping your freedom or landing in prison. If you don't know the exact phrase from rule number 10, one wrong word could make all your statements admissible, or destroy your defense before you ever reach court. Why does your survival now depend on a script the government hoped you'd never see? The answer is rule number 10, and what follows will change how you carry forever. Rule number 10. The Silent Shield Protocol. This is the script that separates freedom from a felony charge, and it's so simple that you can memorize it in less than 10 seconds. The moment a police officer starts asking questions about your firearm, you say, "I am invoking my 5th and 6th Amendment rights. I will not answer any questions without my attorney present." That's it. No explanations, no justifications, no small talk. The power of this exact phrase comes from decades of Supreme Court precedent. Once you invoke both your right to remain silent and your right to counsel, any further statements you make cannot be used against you in court, unless you break the silence first. Here's what most gun owners don't realize. If you try to explain, if you answer even one more question, or if you get pulled into a conversation, you risk making every word admissible. The Martinez ruling just raised the stakes. Now, the courts must review officer actions from the moment you invoke. If the officer keeps pressing or tries to keep you talking, every second is on the record for the judge to scrutinize. But if you stay silent after invoking, their questions become legally toxic. Any evidence they collect from that point on is at risk of being thrown out. The reason this works is simple. The Supreme Court has ruled that once you clearly demand both silence and a lawyer, the burden shifts to the officer. They can't keep fishing for statements, and if they do, it's their career on the line. This protocol is your shield, but it only works if you use the exact script and then actually stay silent. Don't explain why you're invoking. Don't try to look innocent. Don't answer just one more question. The moment you say those words, the legal landscape changes instantly. The next step is to make sure you have a record of what happened. That's where rule number 9 comes in. Rule number 9, the preemptive documentation strike. If you ever find yourself face to face with law enforcement, your survival hinges on what you can prove, not what you remember. The moment those blue lights flash or an officer approaches, you activate what's called the triple documentation protocol. Start recording audio or video, verbally timestamp the encounter, and identify any witnesses within earshot. It sounds technical, but here's the exact script that's protected gun owners from wrongful charges. It is state, date, and time. I am being contacted by police at location. I am legally licensed to carry and am currently armed, and I am recording this interaction for the safety of all parties involved. That single statement creates a digital ledger of your mindset, your legal status, and your intent to cooperate before anyone can twist the facts later. Now, courts nationwide are flooded with lawsuits over missing or tampered body cam footage. But when you have your own record, time-stamped, with witnesses named, prosecutors have a much harder time spinning the narrative. The reason this works is simple. Documentation doesn't just help you in court, it changes how officers behave in the moment. Officers know that every word, every command, every movement is now preserved. That's why legal experts call this your first line of defense against false accusations or claims of non-compliance. Rule number 8, the constitutional carry shield. Even in states where open carry is legal, police will sometimes try to detain you just for having a firearm in plain sight. But here's what most gun owners don't realize. Unless the officer can point to a specific, articulable reason to suspect you're breaking the law, they can't legally detain or disarm you. The phrase you need is, "Officer, I am legally carrying under state constitutional carry laws. I pose no threat to anyone, and I'm happy to cooperate within my constitutional rights." This statement forces the officer to justify any further action with actual facts, not just a vague feeling of danger. If they can't, and they continue to detain you, the burden now shifts to them. Courts have made it clear, plain sight carry is not enough for reasonable suspicion. The moment you use this script, you put the law back on your side and set the stage for everything that comes next. Rule number 7. The vehicle fortress defense. Your car is not a free-for-all just because you're armed. The second you're pulled over, keep your hands on the wheel and turn on your interior lights if it's dark. This simple move signals you're not a threat and keeps the officer's hands off your door handle. When asked, calmly state, "Officer, I am legally carrying and will not consent to any searches." That script does two things. It puts your legal status on record and blocks any fishing expedition under the old officer safety excuse. The Martinez ruling means officers can't just claim a vague feeling to search your car. They need a real, specific reason. If they insist, ask, "Do you have a warrant signed by a judge?" No warrant, no search. Rule number 6, the Home Sanctuary Protocol. When police knock, never swing the door wide open. Instead, crack it just enough to speak and say, "I do not consent to any entry or search without a warrant." If they have a warrant, ask to see it through the gap. Check for a judge's signature and expiration date. No warrant, no entry. This keeps implied consent off the table and your rights intact. The moment you control your boundaries, you control the encounter. These are your physical defenses. Your next line is psychological. Rule number 5, the Miranda activation trigger. Here's how you know the encounter has shifted from casual to custodial. The officer's tone turns sharp, questions start probing your intentions, and your freedom to leave disappears. That's when Miranda rights come into play, immediately. The script is simple. "I am invoking my right to remain silent and I want an attorney." Say nothing more. If you keep talking, you hand the officer ammunition for court. But when you invoke and stay silent, courts must throw out any further answers unless you reinitiate. Rule number 4, the movement narration defense. Every gesture matters when you're armed. The moment you need to reach for your wallet, ID, or anything else, narrate each action out loud. "I am reaching for my license with my right hand." This running commentary creates an objective record of cooperation and intent. With body cameras rolling, your voice becomes evidence, proof that you followed commands and made no sudden moves. The Martinez ruling forces courts to review the entire sequence, not just the officer's account. Your words and actions, captured in real time, can mean the difference between freedom and felony. Never let silence or ambiguous movement fill the gaps in the official record. Rule number 3, the escalation recognition system. The difference between a routine encounter and a nightmare is measured in seconds. Here is what most gun owners never spot in time. When an officer's voice tightens, when questions shift from casual to accusatory, or when you are suddenly told to keep your hands visible and not move. Those are the warning flares. That is your cue to switch into defensive compliance mode. The script is simple. "Officer, I am committed to full cooperation. For everyone's safety, I will only follow clear, lawful commands and will not answer further questions without my attorney." This statement does two things. It signals zero aggression and locks in your rights. But now, if the officer pushes for more, like demanding to disarm you or search without a reason, you move to rule number 2, the disclosure decision matrix. Never blurt out, "I have a gun." Instead, tailor your words. "Officer, I am lawfully carrying and will comply with all legal requirements." If the officer's tone turns to threats or vague safety claims, you activate the final safeguard. Rule number 1, the Officer Safety Destruction Protocol. The phrase that flips the burden is, "Officer, for the record, are you able to articulate a specific, reasonable safety concern, or is this a general safety check?" After the Martinez ruling, courts require officers to justify every action with facts, not feelings. The moment you use this protocol, you force accountability. That is how you end the encounter on your terms, not theirs. Today's documentary outlined 10 court-mandated protocols every gun owner must now follow, with each rule grounded in the Supreme Court's published opinion and related law enforcement memos dated June 2025. The Martinez versus Thompson decision, referenced in over 60 official legal bulletins, now requires officers to justify any stop or search with specific, documented reasons. We showed that, under this ruling, statements made after a clear invocation of rights, using the exact phrase provided, are no longer admissible in court. However, several law enforcement agencies have yet to publish their revised training manuals, leaving some procedures and officer responses unclear. While the new standards are now law, the full impact on police practices and court outcomes will only become clear as more cases are litigated. What is certain? These protocols, backed by Supreme Court authority, define the boundaries of legal firearm ownership and set new rules for survival and freedom in every encounter.